Hello, and welcome to the 36 Family series of YouTube videos about COVID-19 and financial remedies cases in the current circumstances. In this short video, we're going to be looking at arbitration as an alternative to a court-based process, why you would want to arbitrate, and how to prepare for a remote arbitration. I'm joined by my colleagues Rhys Taylor and Andrzej Bojarski, who are both arbitrators. For a matrimonial specialist who hasn't previously arbitrated, to try and embark upon that in the current crisis where everything is being conducted remotely might seem a daunting prospect. So we're going to aim to give you a short guide in this video to show you how straightforward it can be, in fact. And not all cases are clearly suitable for final determination at the present time where there's a great deal of uncertainty, but many are. And we will all have those open files where proceedings have been going on for a long period of time. Perhaps a final hearing had been listed, but which has now been vacated, and clients are desperate for a solution, which the court is not in a good position to give at the moment. And perhaps it's unclear when the hearing is going to be relisted, how long that might take, or whether the court might deem that suitable for remote litigation. So in that context, can I hand over to Andrzej to perhaps tell us a bit more about how arbitration works?
Thanks, Marisa. So at its heart, arbitration is really very simple. It's simply the appointment of an expert to determine the dispute that you've got. So the arbitrator stands in the shoes of the judge that would be dealing with the case if you were in court. Parties often confuse it with mediation, which is obviously something quite different. Mediation is all about the mediator trying to help the parties find agreement, and if they can't agree, then the mediation fails. Arbitration results in a decision which is binding on the parties, and therefore it has finality to it, just as the court process does. Family court judges have, in a number of cases, made it very clear that the arbitrator's decision is binding in a financial remedies dispute, just like the decision of a judge would be. Failing any appealable error in what the arbitrator has done, the court will implement the arbitrator's award. So the parties can be confident that it will resolve their dispute with finality. The main difference, of course, between arbitration and the court is that in the case of the court, you can't choose your judge. You get who's given to you from the listing officer on the day your case appears. Whereas, of course, with an arbitration, the parties at the outset decide who the arbitrator will be and will no doubt want to satisfy themselves that they've appointed somebody who is an expert to deal with the issues in their case specifically. They can also, because they've appointed the arbitrator, go back to the arbitrator during the process quite quickly for the purposes of directions being given to deal with any issues that have arisen in the course of preparing for a hearing. And most arbitrators will deal with that very swiftly by way of an email exchange directly between the parties and them. So whereas with the court, you might be waiting several weeks to get a hearing date just for a straightforward directions hearing, with an arbitration, you can often get a matter resolved within hours and days at the very latest, if there is other work that's getting in the way of the arbitrator dealing with it. So it's a little bit, if you want to draw a parallel with healthcare, a little bit like going private compared to going into an NHS queue. Everything is going to be more efficient and slicker. And as a result of cases moving through more quickly, generally speaking, it's overall a money saving for the parties. And of course, another big difference is that unlike the court process, which is something of an all or nothing approach to litigation, in an arbitration, you can just take specific issues to the arbitrator at any particular point in time. It could be something as limited as just the directions that are necessary at the first appointment stage, whether you're appointing valuers, the terms of a letter of instruction, the identity of an accountant to value a company, any of those sorts of issues that arise. And indeed, next week, for example, I'm dealing with a preliminary issue on an arbitration, which is all about whether a separation agreement should be held to be binding between the parties or not. So a discrete issue, once that's resolved, the party will either try and resolve their dispute, or they'll go back into the court process or back into arbitration if need be to deal with the matter. So it's worth also just finally, before I hand over to look at the practicalities of it, thinking about the fact that although arbitration is a process that's akin to court, just like court cases, many arbitrations settle. And just as the door of the court tends to focus people's minds towards settling their dispute because of the fact that it's going to be taken out of their hands by a judge, often the appointment of an arbitrator has a similar effect. And a very large number of the cases where I've been appointed as an arbitrator, and I know in other circumstances as well, have settled through consent by the parties. Whether it would have settled without the arbitration agreement, who knows? But there's certainly a mind-focusing exercise that goes through that. So that's really what arbitration's about. I think, Rhys, perhaps you want to talk about how you formally go about starting an arbitration and dealing with the practicalities of it.
Yes, thank you very much, Andrzej. As you said a moment ago, at its heart, an arbitration is merely an agreement. How do you arrive at that agreement? Well, for a financial arbitration, you need to complete the form ARB1FS. That's conveniently available on a website which Andrzej and I host with some others called familyarbitrator.com. And you can either download a PDF or Word copy of that document there. You can fill in some basic details as to who the parties are, and you then have to describe your dispute. Now, for financial remedies cases, that's really straightforward. You can just say, I would like the arbitrator to resolve all issues in the applicant's financial remedy claim, and that will encompass all of the issues that the court would have jurisdiction to deal with. Slightly different if you're dealing with a Talata case, because you would have to define what is in dispute. And you might say, for instance, we want the arbitrator to deal with all of the issues as set out in a letter before claim, or all issues as set out in some pleadings, or something like that. But for financial remedies, very, very straightforward. There's then a box to insert the arbitrator that you want to appoint, and then the parties sign some declarations that they understand they're entering into a formal process that they wish to be binding upon them. And all of the cases which have been determined about the enforceability of IFLA arbitrations have upheld the binding nature of those agreements. And so the parties do need to understand that what they are signing up to, they will be kept to. That ARB1 FS is then sent off to the arbitrator, as it were, as an invitation to the arbitrator to arbitrate. And having checked over the form, checking there's no conflicts or anything like that, the arbitrator can then accept the appointment to be an arbitrator. And typically that's done by sending some terms and conditions which are also available. A template is available on the Family Arbitrator website to say, well, I'm prepared to deal with your dispute on these terms. The parties sign that, and then the arbitrator co-signs it, and then the agreement is constituted and your arbitration is underway. Probably the most difficult thing about sorting all of that out is deciding who you want as your arbitrator. Now then, it may be that the parties can immediately agree that they would like Mr. Andrzej Bojarski to hear their arbitration, and that's very straightforward. They can just put Andrzej's name in, and that's no problem at all. But you may have a situation where one side wants Mr. Andrzej Bojarski, but then the other side wants somebody else, and they can't really agree on who should be appointed. And there can be a bit of a tussle sometimes in deciding who to appoint and how to go about that, and there really shouldn't be. If the parties can't readily agree on a name, you could adopt a procedure like one conventionally adopts for the appointment of an expert, with one side picking 3 names, putting them to the other side, and then the other side can choose one of them. That's one way of dealing with it in a fair-handed way, so that both sides get a say. Or if the parties can't bring themselves to do that, you can approach IFLA, and they will appoint somebody from the list, having considered the nature of the case and the geography of where the parties are based. So that really doesn't need to be an obstacle to getting an arbitration underway.
Thanks, Rhys. So I'm just going to talk a little bit about preparing for an arbitration, and how you prepare really, I suppose, depends really on where you are at with the case itself. There'll be lots of cases at the moment that are coming into arbitration during the COVID-19 epidemic, which are already listed for a final hearing due to take place in the next few weeks. So those cases are generally already trial ready, and it's simply a case of replacing the core hearing with an arbitration. And so in most of those cases, all that's going to happen is that the existing directions are going to follow through. The parties will have exchanged all their updating disclosure and witness statements and anything else that's required for the purpose of the final hearing. they'll appoint the arbitrator, and the matter will probably proceed straight to the final hearing of the arbitration without any further involvement. If, on the other hand, you're at the other end of the process where you're just starting out on a case and you haven't yet got to the stage of even having issued a Form A or exchanged any disclosure, the arbitrator's going to need to consider at an early stage directions for getting the matter ready for a hearing. Now, the parties may well take it out of the arbitrator's hands by agreeing those directions in the first instance. And in most cases, that's what happens, and the arbitrator is simply asked to approve a timetable which the parties have settled upon, and it's quite rare that the arbitrator is going to have a difficulty in doing that. If the parties are struggling to agree what the timetable should be, there is already a pro forma template for that within the IFLA rules, and there's a standard process which very much models itself on the standard FPR process for which the rules contain for dealing with financial remedy disputes in the courts. So that's something which practitioners are going to be very familiar with and shouldn't have any real difficulty dealing with. On the other hand, there won't be those cases where the parties feel that they want the arbitrator to himself or herself decide the timetable. And in those cases, there's likely to be an early hearing, which is probably going to be done by telephone. They were doing them by telephone even before the COVID-19 epidemic made that the norm for these sorts of things, or indeed by video link if that's more convenient for the parties, and the arbitrator will then set the timetable for the case to take it through to an effective hearing. It's also worth bearing in mind that not all cases will require a hearing. There are many arbitrations that are dealt with purely on paper because the issues are such that they don't require the hearing of evidence or anything other than written submissions on the points. So there's a whole variety of different routes that the parties may wish to take towards the arbitration itself. In terms of the hearing itself and preparing for that, that's going to be very similar to the hearing preparation for a court hearing in terms of preparing a bundle of relevant documents and making sure that the arbitrator has everything that is available. So I don't think there's anything there that's going to cause any difficulties for somebody who's never done an arbitration before in terms of getting used to that and preparing effectively. But in terms of what happens on the day of the arbitration itself, Marisa, perhaps you're going to say a little bit about that?
Thank you, Andrzej. I'll say a little bit at first about what would happen in normal circumstances. The arbitration is usually arranged to take place either at counsel's chambers or solicitors' offices. There's not usually any difficulty in agreeing the location. It just needs to be somewhere where there effectively is a large enough room to accommodate everybody around the table, and two breakout rooms so that the parties have somewhere to go and speak confidentially to their representatives. There will be arrangements made in advance as to how the hearing is going to be recorded, and then there's often a manual recording device in the room where the hearing is taking place. When arriving in the morning, parties and their advisors can have their discussions in their usual way, and then to proceed into the hearing room where the arbitrator is. And I often find that there is a much more useful, constructive, engaged discussion at the outset, partly to set out the ground rules for the hearing, what everybody's going to be called, usually sir or ma'am for your arbitrator, how the parties want to be referred to, but also how the day is going to progress. But there's then often a more structured focus on what issues need to be resolved in the light of the respective counsel's notes that have been exchanged, clarification about any legal points that are being taken, whether certain issues are going to be dealt with on submissions or by way of evidence. So in effect, streamlining the process and giving the parties control over the process. Apart from that, it's very much business as usual in the sense that there may be a formal opening from counsel, or there may not if your arbitrator doesn't require that and the parties are happy that all of the issues are at hand. Witness evidence is given in the usual way. Other witnesses can be called, sometimes by telephone if they're not present at the arbitration, or by attending in the same way that they would do a courtroom. You can sit for as long as you like, you can take breaks during the course of the day. There's much more flexibility in that respect. Perhaps if a party has particular health needs that mean you need to break more often, those sorts of issues can be dealt with much more informally. And then when the end of the evidence has been reached, there's usually discussion about how submissions are going to be given, whether they're to be given that day or at another time or in writing, and then a timetable put in place for the arbitrator to hand down their award. And there's no reason in principle why all of that can't take place remotely as well via platforms such as this that we're using today, which have facilities for breakout rooms and so on. But Andrzej, is there anything in particular that you'd like to say about conducting an arbitration remotely?
Well, the reality is it's going to be the same process that you've just described, but without the convenience of everybody being in the building at the same time. So everybody's got to give a little bit of thought to the challenges that inevitably remote working presents. But I think we've all started to get used to those because we're doing so much of our work remotely now in any event. And it's fair to say that I think it's easier to conduct a private arbitration through remote means than it may be dealing with the court remotely through either a video or telephone link, simply because the infrastructure is still creaking a little bit there on that side. So video is certainly the best way to do it. We've been using Zoom video conferencing in chambers with considerable success, both for private FDRs and for arbitrations. It doesn't require much in the way of bandwidth, so parties and lawyers don't require to be on a particularly fast broadband connection in order to make it work effectively. Certainly had one case where a party was joining using just a data signal on their mobile phone on a 4G signal, and that seemed to work perfectly adequately. That's all easily done and works fairly well once people get used to it. You do need to think about some of those practicalities in terms of, for example, breakout rooms, which when you're physically in a building is fairly easy just to go off to a different room and sit in a different space. But of course, that's more difficult to do virtually. There is a facility within Zoom that allows breakout rooms. It could be used. We've generally found it's probably better if parties have their own parallel system of communication between themselves, clients and lawyers and solicitors, rather than trying to use the breakout rooms which the arbitrator controls. Certainly on one case that I dealt with, we had a private WhatsApp group between the solicitor, myself as advocate, and the client, so that we could pass messages to each other even during the hearing itself, quite confidentially and quietly. So effectively the conversations that would be a whisper behind the hand in the courtroom were all taking place by way of WhatsApp. So there are clearly solutions to all these things, but you just need to think about how you do in a practical way remotely those things that you do intuitively in court face to face. You do also need to bear in mind practicalities such as how a witness is going to deal with the documents. There is the facility to share documents on the screen, but it's certainly preferable if somebody's going to be giving evidence that they have access to the full bundle themselves. If they're fully IT literate and they've got good IT facilities at home so they can see the screen with the arbitrator and the advocates on at the same time as they can see documents, it's probably fine for them to work from an e-bundle. But I think in many cases it's worth thinking about the witnesses themselves having a paper bundle in their possession at home, wherever they're doing the call from, so that they can be referred to documents and so that everybody can be confident that they've got access to the documents that they're being referred to. And it's also important just to think about how the hearing is run. There may well be technical issues during the day, so people need to think about how anyone communicates to everyone else if their signal drops out and they lose contact with the connection. And it's also worth bearing in mind, as I think we've all got to know, that working remotely, whether it's conferences, private FTRs or arbitrations, is unusually fatiguing. Maybe we're still getting used to it, but it is more demanding perhaps than sitting in a courtroom for 2 or 3 hours with everybody together. So people do need to just give some thought as well to taking regular breaks and making sure that everybody can get through the day working efficiently and effectively, because it is quite draining, isn't it, Rhys?
Yes, it is. And I just add one other little practical point, that it's so much easier in the Zoom environment to end up tripping over one another. You think somebody has finished speaking, but they haven't, and you're trying to interrupt, or you appear you're interrupting. So when I've been chairing meetings, I've asked people to be especially courteous in the way in which they approach things, and to not interrupt unless they absolutely have to, and then by raising their hand in the first instance, giving me the opportunity to indicate whether or not I want them to speak at that point or not. And I think one just needs to abide by those courtesies, which ordinarily should be afforded in court in any event, but we all know that there's a bit more chipping in when you're there in real life.
Well, thank you, Rhys and Andrzej, and thank you for tuning in. I hope that's been useful. If so, please do subscribe to our 36 Family YouTube channel, or have a look at our other short YouTube videos. We've been looking at pensions on divorce in the coronavirus pandemic, private FDRs, barrel and barter jurisdictions, and I'm sure more to come. Thank you and goodbye.